right, members of the jury, thank you for your attention during the trial. Please pay attention to the instructions you're about to receive. Now, if you've been taking notes, you're welcome to continue doing so, but before you make that decision, be advised you will receive a written version of these instructions. Colin Griffith, the defendant in this case, has been accused of the crimes of first-degree murder and kidnapping. Murder in the first degree includes the lesser crimes of murder in the second degree and manslaughter, all of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find that Catherine Griffith was killed by Colin Griffith, you will then consider the circumstances surrounding the killing in deciding if the killing was first-degree murder or was second-degree murder or manslaughter, or whether the killing was excusable or resulted from the justifiable use of deadly force. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. 1. When the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2. When the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel and unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I will now instruct you on the circumstances that must be proved before Colin Griffith may be found guilty of first-degree murder or any lesser included crime. Now, there are two ways a person may commit first-degree murder. One is known as first-degree premeditated murder, and the other is known as first-degree felony murder. To prove the crime of first-degree premeditated murder, the state must prove the following three elements beyond a reasonable doubt. First, that Catherine Griffith is dead. Second, that the death was caused by the criminal act of Colin Griffith. And third, that there was a premeditated killing of Catherine Griffith. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. However, the period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. To prove the crime of first-degree felony murder, the state must prove the following three elements beyond a reasonable doubt. First, that Catherine Griffith is dead. Second, that while engaged in the commission of kidnapping, Colin Griffith caused the death of Catherine Griffith. And third, that Colin Griffith was the person who actually killed Catherine Griffith. In order to convict the defendant of first-degree felony murder, it is not necessary for the state to prove that Colin Griffith had a premeditated design or intent to kill. To prove the crime of kidnapping, the state must prove the following three elements beyond a reasonable doubt. First, that Colin Griffith forcibly, secretly, or by threat confined, abducted, or imprisoned Catherine Griffith against her will. Second, that Colin Griffith had no lawful authority to do so. And third, that Colin Griffith acted with intent to inflict bodily harm upon or to terrorize Catherine Griffith, or commit or facilitate the commission of any murder. In order to be kidnapping, the confinement, abduction, or imprisonment, A, must not be slight, inconsequential, or merely incidental to the murder. B, must not be of the kind inherent in the nature of the murder. And C, must have some significance independent of the murder, in that it makes the murder substantially easier of commission or substantially lessens the risk of detection. Secretly means the defendant intended to isolate or insulate Catherine Griffith from meaningful contact or meaningful communication with the public. Now, in considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crimes of which he's been accused, there may be evidence of other acts that would constitute a lesser included crime or crimes. Therefore, if you decide that the main accusation has not been proven beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of first-degree murder, as I've said, are second-degree murder and manslaughter. The lesser crime indicated in the definition of kidnapping is false imprisonment. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. First, that Catherine Griffith is dead. Second, that the death was caused by the criminal act of Colin Griffith. And third, that there was an unlawful killing of Catherine Griffith by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. Again, an act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove Colin Griffith had an intent to cause death. To prove the crime of manslaughter as a lesser included crime in count 1, the state must prove the following 2 elements beyond a reasonable doubt. First, that Catherine Griffith is dead. And second, that Colin Griffith intentionally committed an act or acts that caused the death of Catherine Griffith. Now, every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is called negligence. Colin Griffith cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that Colin Griffith had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. To prove the crime of false imprisonment as a lesser included offense in count 2, the state must prove the following 2 elements beyond a reasonable doubt. First, that Colin Griffith forcibly, secretly, or by threat confined, abducted, imprisoned, or restrained Catherine Griffith against her will. And second, that Colin Griffith had no lawful authority to do so. Again, secretly means Colin Griffith intended to isolate or insulate Catherine Griffith from meaningful contact or meaningful communication with the public. It is a defense to the crime of first-degree murder and all of the lesser included crimes of first-degree murder if the actions of Colin Griffith constituted the justifiable use of deadly force. Deadly force means force likely to cause death or great bodily harm. Again, great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm. Colin Griffith does not have the burden of proving that he was justified in using deadly force. Instead, for you to find the defendant guilty, the state must prove beyond a reasonable doubt that the defendant was not justified in using deadly force. The law on justifiable use of deadly force is as follows. Colin Griffith was justified in using deadly force if he reasonably believed that such force was necessary to prevent imminent death or great bodily harm to himself. Colin Griffith had no duty to retreat before using deadly force. If Colin Griffith was in a residence in which he had a right to be, he had no duty to retreat and had the right to stand his ground and use force, including deadly force, if he reasonably believed that such conduct was necessary to prevent imminent death or great bodily harm to himself. The use of deadly force is justifiable if Colin Griffith reasonably believed that the force was necessary to prevent imminent death or great bodily harm to himself while resisting any attempt to murder him or commit an aggravated battery or aggravated assault upon him. In deciding whether Colin Griffith was justified in the use of deadly force, you must consider the circumstances at the time the force was used. The danger need not have been actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real that the defendant actually believed the use of deadly force was necessary. Moreover, to justify the use of deadly force, a reasonably cautious and prudent person under the same circumstances would have believed the use of deadly force was necessary. Residence means a dwelling in which a person resides, either temporarily or permanently, or is visiting as an invited guest. However, the use of deadly force is not justified if you find that the defendant was attempting to commit, committing, or escaping after the commission of kidnapping. If you find that Colin Griffith, who, because of prior threats or difficulties with Catherine Griffith, had reasonable grounds to believe that he was in danger of death or great bodily harm at the hands of Catherine Griffith, you may consider this fact in determining whether the actions of Colin Griffith were those of a reasonable person. If you find that at the time of the alleged first-degree murder or any lesser-included offense, Colin Griffith knew that Catherine Griffith had committed an act or acts of violence, you may consider that fact in determining whether Colin Griffith reasonably believed it was necessary for him to use deadly force. If you find that Catherine Griffith had a reputation of being a violent and dangerous person, and that her reputation was known to Colin Griffith, you may consider this fact in determining whether the actions of Colin Griffith were those of a reasonable person in dealing with an individual of that reputation. If you find that Catherine Griffith had a reputation of being a violent and dangerous person, you may consider this fact in determining whether she was the initial aggressor. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Colin Griffith and Catherine Griffith. Now, if you find that Colin Griffith committed second-degree murder or manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime he personally carried, displayed, used, threatened to use, or attempted to use a weapon, you should find him guilty of second-degree murder with a weapon or manslaughter with a weapon. A weapon is defined as any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction. If you find that Colin Griffith committed second-degree murder or manslaughter, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a weapon, then you should find him guilty only of second-degree murder or manslaughter. The defendant has entered a plea of not guilty. This means you must presume or believe that the defendant is innocent. This presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and that the defendant is the person who committed the crime. The defendant, on the other hand, is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced during the trial and to it alone that you're to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence itself, a conflict in the evidence, or a lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you, as the jury, to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some other things you should consider are as follows. Did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Did the witness's testimony agree with the other testimony and other evidence in the case? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Now, the fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Also, expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like any other witness, a juror may believe or disbelieve all or any part of an expert witness's testimony. It is entirely proper for a lawyer to speak with a witness about what testimony a witness would give if called to the courtroom, or discussing his or her testimony with a lawyer. You may rely upon your own conclusions about the credibility of any witness. As I've said, a juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove guilt by evidence. The defendant exercised a fundamental right by choosing not to become a witness in this case. You must not view this as an admission of guilt, nor be influenced by his decision in any way. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and weighed with great care to make certain that it was freely and voluntarily made. If you conclude that the defendant made the statement, you must also determine from the evidence whether the defendant's statement was freely and voluntarily made. In making this determination, you should consider the total circumstances, including, but not limited to, whether, when the defendant made the statement, he had been threatened to get him to make the statement, and whether anyone had promised him anything to get him to make the statement. If you conclude the defendant's, If you conclude the defendant made the out-of-court statement, but that it was not freely and voluntarily made, you should disregard it. The following are some general rules that will apply to your deliberations, and you must follow these rules in order to return a lawful verdict. First, you must follow the law, as I am now spelling it out for you in deciding your verdict. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the laws in this case. All of us are depending upon you to make a wise and legal decision. This case must only be decided upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. And remember, the lawyers are not on trial. Your feelings about them must not influence your decision in any way. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is my job to determine what an appropriate sentence would be if the defendant is found guilty. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. And your verdict must not be influenced by feelings of prejudice, bias, or sympathy. It must be based on the evidence and the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that makes you think I prefer one verdict over the other. You may find the defendant guilty as charged or guilty of such lesser included crimes as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then, of course, your verdict must be not guilty. Now, if you return a verdict of guilty to the charge of first-degree murder, it is not necessary that all of you agree the state proved first-degree premeditated murder, and it is not necessary that all of you agree the state proved first-degree felony murder. Instead, what is required is that all of you agree the state proved either first-degree premeditated murder or first-degree felony murder. Remember, the verdict must be unanimous. Each of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. It must be in writing, and for your convenience, the necessary verdict form has been prepared. It is fairly straightforward, but the law requires that I show it to you, explain it, and read it into the record. And this is it. It is 2 pages long. At the top of the first page is what we call the caption. That gives you the information about where the case is pending, who is involved, and so forth. It reads, in the Circuit Court of the 10th Judicial Circuit of Florida in and for Polk County, with the case number 53-2024 CF 8410A000XX, and the division assignment underneath, F9. You'll then note the names of the parties pitted against each other. State of Florida, plaintiff, versus Colin Griffith, defendant. It is entitled, not surprisingly, Verdict. It then begins, and you'll notice count 1 is on page 1. We, the jury, find as follows as to the defendant in this case. As to count 1, you'll notice a parenthetical there which reads, select only one. That's a simple reminder that you can only have one verdict for each count. There are 4 choices underneath, marked A through D, with a line out to the left. That's where you'd place your mark when you've agreed on your verdict. That can be a check, X, four-person initials, whatever you like, so long as it's clear and singular. Those choices are: A, the defendant is guilty of first-degree murder as charged in the indictment. B, the defendant is guilty of second-degree murder, a lesser-included offense. C, the defendant is guilty of manslaughter, a lesser-included offense. D, the defendant is not guilty. And then at the top of page 2 is count 2. As to count 2, again the reminder to select only one. 3 choices for count 2 marked A through C. A, the defendant is guilty of kidnapping as charged in the indictment. B, the defendant is guilty of false imprisonment, a lesser included offense. C, the defendant is not guilty. Now, if in count 1 you found the defendant guilty of either first-degree murder or second-degree murder, you'll notice this next section called special findings. And there's a question, depending on your verdict in count 1, there are 2 potential questions here. But the first question you would only answer if you found the defendant guilty of first-degree murder or second-degree murder. And that question is, 1, did the defendant actually kill Catherine Griffith? The reminder again to select only one. These findings also have to be unanimous, and the reasonable doubt standard applies as well to these findings. So, did the defendant actually kill Catherine Griffith? 2 choices, yes or no. Then the second question for count 1, and this is if you find the defendant guilty of second-degree murder or manslaughter. And that question is, during the commission of the offense, did the defendant personally carry, display, use, threaten to use, or attempt to use a weapon? Again, select only one, yes or no. So, if you find the defendant guilty of first-degree murder, you would only answer question 1. If you find the defendant guilty of second-degree murder, you would answer both questions. If you find the defendant guilty of manslaughter, you would only answer the second question. If you find the defendant not guilty, do not answer either question. It concludes, so say we all, this blank day of February 2025, and then there's a place for the four-person signature, and underneath to print his or her name. Now, a separate crime is charged in each count of the indictment, and although they have been tried together, each crime and the evidence applicable to it must be considered separately, and a separate verdict rendered as to each. Now, a finding of guilty or not guilty as to one crime must not affect your verdict as to the other crime charged, except, as I'm about to explain to you in the instruction regarding legally interlocking counts. The crime of first-degree felony murder, charged in count 1, is linked to count 2, kidnapping, and that the crime charged in count 2, kidnapping, is an element of the first-degree felony murder charged in count 1. You should first consider the evidence applicable to count 2. If you find that the crime charged in count 2, kidnapping, has not been proven beyond all reasonable doubt, you must find the defendant not guilty of first-degree felony murder in count 1. If, on the other hand, you find that the crime charged in count 2, kidnapping, has been proven beyond a reasonable doubt, you must then consider the evidence applicable to first-degree felony murder charged in count 1. Now, a guilty verdict on count 2, kidnapping, does not require a guilty verdict on the charge of first-degree felony murder in count 1. You should find the defendant guilty on the charge of first-degree felony murder in count 1 only if you find all the elements of the crime including the essential elements contained in the crime charged in count 2, kidnapping, were proven beyond a reasonable doubt. However, the alternative crime of first-degree premeditated murder in count 1 is not linked to any other count in the indictment. A finding of guilty or not guilty as to count 2 must not affect your verdict as to the first-degree premeditated murder in count 1. In just a few moments, Mr. Hertel will take you to the jury room. The first thing that you should do is select a foreperson who will preside over your deliberations, much like the chair at a meeting. It is that person's main function to see to it that your discussions are carried out in an organized fashion and to make certain that each of you has a fair opportunity to be heard. It is that person's job, as I've said, to sign and date the verdict form when you have agreed on your verdicts, and to bring the verdict form to the courtroom when deliberations have concluded. During deliberations, jurors must communicate only with one another, and only when all jurors are present in the jury room. That means if someone steps into the restroom, all discussions about the case must stop until that person returns. You are not to communicate with anyone outside the jury about this case until you have reached a verdict. Remember, you must not talk about this case in person or through the telephone, in writing, or by use of an electronic device, or by any use of electronic media. Do not contact anyone to assist you during deliberations, and know that these rules will continue to apply until you are discharged at the very end of the case. If you become aware of any violation of these instructions, or any other instruction I have given you during your service, you must tell me by giving a note to the bailiff. Now, many of you have cell phones, perhaps other types of electronic devices with you. The law does not permit those things to go to the jury room with you during deliberations. Mr. Hertel will be collecting those things from you. They will be securely stored away in an evidence closet. No one will have access to them. And they will be returned to you promptly upon your discharge. Or if your deliberations aren't concluded today, you will be given them for the overnight recess. I would ask that you put those things on silent or vibrate. I do have other business to conduct in the courtroom. It would be distracting if your cell phones are ringing over there in the closet. If you need to communicate with me during deliberations, please do that in writing by sending a note through the bailiff. Now, if at the time you send such communication you have taken a vote, please do not disclose the nature of your vote to us. That has nothing to do with any of our functions. It is your private affair. If you have questions, I will have to talk with the lawyers about your questions before I answer, if I'm able to answer. That could take some time. If you are able to continue deliberating while you await my answer, you may certainly do so. If I am able to answer a question and the answer is simple, I will very likely respond in writing on the same piece of paper that you sent to me. If that happens, please keep that piece of paper with the evidence. It must be filed in the court file at the conclusion of the case. If the answer is more complex, you may be brought back into the courtroom for some additional oral instruction. During the trial, several exhibits were received in evidence. You may examine whatever exhibits you think will assist you during your deliberations. They will all be sent back to the jury room with you when you begin to deliberate. In closing, let me remind you, it is important that you follow the law as I have just spelled it out for you in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For centuries, we have agreed to live by the Constitution and the law. No juror has the right to violate the rules that we all share. Any objections to the instructions as orally given or any additional instructions requested by the state?
No, Your Honor.
By the defense?
No, sir.
All right. Before I identify our alternate jurors, which is my least favorite part of the trial, and send you back to deliberate, I want to know if any of you are aware of any violation or if any of you have been exposed to any information, anything that might impact your ability to continue serving fairly and impartially. If something you're supposed to make me aware of has not been brought to my attention, please raise your hand. All right. There are no hands raised. You all know your juror numbers, correct? Juror number 1981288, 1981110, and 1980802, the three ladies on the far end of the back row. You are our alternate jurors. You will not be going back to deliberate. There are a few things I would like to say to you before I discharge you. So if you would stay behind in the courtroom with us, the bailiff will make sure that some lunch is set aside for you to take with you. You're welcome to do that. So if you'd stay behind with us for just a moment. For the rest of you, we will send back the written instructions, the verdict form, and the evidence to you in just a moment. You may now retire to consider your verdict.
All rise, please. Can you bring your notepad?
Ladies, I'm not sure how you feel. Oftentimes the alternate is quite disappointed to find out they've devoted so much of their time to the system and then don't get to do really the most important job of the juror back in the jury room. Many alternates are quite relieved to find out they don't have to go through that process. Wherever you fall on that spectrum, I hope that you understand that you have performed a vital service by being here. Across the nation every day, in state and federal court, in criminal and civil cases alike, alternate jurors are selected, many times more than one, such as in this case, and more often than you might think, the alternate or alternates are called upon to take the seat of someone who is excused for one reason or the other during the case. That is especially true and happens frequently in cases covered by the media. This case has received significant media attention, national media attention, and the danger that a friend or family member spouts something off about what they saw on the news that rings a bell with you, or folks just approaching you, trying to talk to you. The danger is quite real that jurors become prejudiced during the trial. So that's why we have multiple jurors. Also, the fact that it was over a week-long trial. So I want to make sure that you understand what a vital service you've performed by being here, and here's why it's important. If something had happened to those who are now back there deliberating, and I did not have an alternate or sufficient number of alternates to replace those folks, and the parties could not agree to proceed with fewer jurors than they're entitled to under the law, in this case 12, my hands would have been tied. I would have had no choice but to scrap everything, send everyone on their way, and start all over on another day. And you know just what an expensive proposition that is for everyone involved, your fellow jurors, and the community of taxpayers. So you have indeed performed a vital service. I've been telling you you cannot talk about this case or look things up. You are completely released from both of those orders. You can talk to anybody you want to, including the people here. They can't approach you, but if you had questions or comments, you can approach them. You're welcome to stay and see what happens. Want to make sure that you get some lunch. But you are also equally free to forget about this case, refuse to talk to anyone, and be on your way. That's going to be up to you. On behalf of the entire 10th Circuit and all assembled here, I humbly thank you for your service. You are now discharged. I think we need to wait on the bailiff because he's going to take you out this back door, so give us just a moment.